The information provided on this podcast is not legal advice and is intended for the sole purpose of providing education and legal information. Laws change over time, and the information provided on this podcast may not be up to date. We make no warranty, express or implied, regarding the information provided by our team or our guests on this podcast. The information should not be construed as legal advice and does not create an attorney-client relationship with us or any of our guests on the podcast. If you would like to consult with an attorney, please call 1-800-VICTIMS. That's 1-800-842-8467 for attorney referral contact information. This podcast provides a platform for the exchange of ideas and information to help educate crime victims on their rights. Some content will include topics and materials that may involve descriptions of violence or assaults which can be distressing to victims and survivors. It may also impact service providers experiencing vicarious trauma. Welcome back to part 2 of our discussion. Let's pick up where we left off. So Blake, I want to transition now and talk to you a little bit about T visas. So maybe we can start by first getting an idea about what a T visa is.
Sure. And let me start by just giving a little bit of background in terms of like the work that we do at the clinic. I think we're going to be speaking about special immigrant juvenile visas in a minute, but the vast majority of the work that we do at the clinic are U visas, Vawa applications, juvenile applications, which we'll be talking about soon, and asylum. We handle very little applications for individuals applying for a T visa. And our hope, and our continued hope is that individuals that qualify for a T visa will either self-identify or be identified by law enforcement. Because so what an individual who may qualify for a T visa is somebody who is a victim of human trafficking. Okay, and so that's somebody who is being trafficked either for forced sex or for forced labor. And we can talk a little bit about it, but there's certain questions that are relevant just to start the conversation with somebody, which might include so did you have the ability to freedom to travel while you were working in this particular place? Was it a work where after you were done you could leave, or where you went was controlled by your employer? You may ask questions also about was alcohol or drugs something that was provided to you as part of your employment? So you're also looking at what was the workday like? How long was the workday? Was your pay given to you regularly? Was your passport taken from you? So these are some of the kind of identifying or maybe exploratory questions you might be asked by an attorney. And the reason why they're asking those questions is to start to think about whether or not you were either victim of the sex trafficking or victim of labor trafficking, because it's a fairly broad definition about what it means when we look at it. And essentially, it's an individual who's been recruited, they've been held, or they've been moved by force, by fraud, or coercion for the purposes of a commercial sex act or labor.
So it sounds like with the sort of multitude of factors that we're looking for a degree of control from the employer to the employee, or in this case, the victim?
Yeah, so in some of the cases that we've seen include labor trafficking, where the person was maybe promised a good job, promised a work visa, and then so came to the United States under the assumption that they were going to have a good paying job, a legal job even, and then the facts were changed essentially in that case, where the individual was working at a restaurant, long hours, and then at the end of the shift they were taken in a van and kept in a garage. And then the next day brought back to the restaurant to work long hours, and then the cycle continued. So that exactly is your point, is the control that the employer was holding over the individual.
It seems like in that case there was a very limited amount of free movement that was that the survivor, the victim in that case, was able to was able to exert over their own life. Would you say that's pretty common in T visas?
Yes. Other cases that we've seen is, so this was the case one classic example you think about with trafficking is being brought into the United States on account of trafficking. But actually, the law requiring is that they're in the United States on account of it. And so we have seen trafficking within the United States from one state to another state, for example, also counts as human trafficking, even for immigration purposes.
Now, with relation to the T visa and the U visa, you mentioned with the U visa that it's essentially provides deferred action. It provides a temporary relief. How does that relate to the T visa? Is it similar?
Well, they're very similar. And so the reason why the U visa provides that deferred action initially is simply due to the number of applicants and the number of visas available. So it's a process. So first the individual gets the deferred action until there's a U visa available. But Congress has set 10,000 visas available for U applicants every year. Same thing for T visas. But there's significantly less applicants for a T visa than for a U visa. Just as I mentioned, in our clinic, I've been at the immigration clinic 10 years at this point, and we've really only handled, I'd say, less than 10 T visa applicants. Whereas, I couldn't count the number on the others. So, and I think that's a common trend nationwide. And so there's less than the statutory cap of applicants made every year. So in a way, it's a faster process in terms of getting that T visa. But they're very similar in the sense that somebody who qualifies as a victim of human trafficking is eventually going to get a permanent resident status after they've been on the T visa for 3 years. They can make that application exactly the same as the U visa. The difference is that it goes a little bit faster because the statutory cap is never met. There are some additional benefits. You can think about an individual who might qualify as a survivor of human trafficking is going to need access to resources quickly. And Congress has made it possible for even applicants for a T visa to get federal benefits to help them protect themselves and get their feet grounded even before they get the T visa. If they're in the application process, they can qualify for refugee benefits, which include potentially housing benefits, includes potentially some limited cash aid and other health benefits while they're even in the process, because Congress realized that this individual may be in a particularly vulnerable state, especially at the initial stages.
I see. That is very interesting. And as far as the steps for applying for a T visa, are they similar with respect to a U visa?
They are pretty similar. So for an applicant who's over 18, they have to cooperate with reasonable requests for law enforcement. One material difference is you don't need that law enforcement to sign the certification. If you remember when I was talking about the U visa, I said law enforcement needs to sign it. If they don't sign it, we're done.
Certification, yeah.
Yeah, that certification. Whereas for the T visa, the law enforcement, you need to be willing to cooperate with law enforcement in their reasonable requests for assistance, but you don't need the certification. There's no mandatory requirement that they sign this form that was created by immigration. So what you may have, for example, is some correspondence between the law enforcement agency. It's frequently the FBI or the U.S. Attorney's Office, like reporting a crime, for example, or just that communication as, to see how the crime was investigated. At the very least, you need to show that for individuals who are over 18, that the crime was reported.
I see, and that may even speak to the self-identification that you talked about earlier.
Right, yeah.
Okay. Now, as far as some more information about T visas, if there's possibly someone listening that either might self-identify as potentially someone who would be interested in a T visa, or if one of our audience members knows someone who might qualify for a T visa, would you recommend the same either organizations or the same groups for more information?
I would, and I would also mention WEAVE in Sacramento, which is Women Escaping a Violent Environment. And there's also my sister's house in Sacramento as well. Both those organizations are excellent at helping survivors of trafficking.
And we'll also provide the information for Weave and My Sister's House in the podcast descriptions. If there's any listeners outside of the Sacramento area that would like assistance, you can also reach out to either Weave or My Sister's House, and they can certainly provide some additional resources in your area if you don't happen to live in the Sacramento area. Now, Blake, you did mention a little bit earlier in our discussion the special immigrant juvenile status. I'd like to now bring up that part of our conversation here. Can you talk a little bit about the special immigrant juvenile status and maybe give an idea to our listeners as to what it is?
Yes. So the special immigrant juvenile status is for individuals who are undocumented that were either abused, abandoned, or neglected by at least one parent. And it's in their best interest to remain in the United States, and it's not in their best interest to be returned to their native country. And so for most individuals, it has to be that they're under 18. There is an exception sometimes for individuals under 21, but most it's under 18. And why is that? Because it requires, this is an additional step, it requires a state court, like a family court, probate court, juvenile court, dependency court judge, to make that factual determination that I was just mentioning, that the child was abused, abandoned, or neglected by at least one parent, and it's in their best interest and not in their best interest to be returned to their home country. So that finding is actually not made by immigration. It's made by what's called a juvenile judge. But a juvenile judge is just any judge that has jurisdiction over minors, which are those that I mentioned. So the reason why most of the time that the child has to be under 18 is because a lot of these courts lose jurisdiction once a child turns 18. For example, a judge can't make a custody determination for a young person who is 19 years old. The one exception is guardianships. And so in guardianships, we have a specific rule that or statute that California passed within the last couple of years, which extends the jurisdiction of judges to make guardianships for young folks who are under 21. But that just in guardianship. So for most, we do our outreach at high schools and community events, and we want to get the word out to people to be informed of this law, because you're dealing with a particularly vulnerable individual, right? Somebody who is generally a child and then has been abused, abandoned, or neglected by at least one parent. So we're trying to get some information out into the community that this is something to at least have some basic understanding of, so that if somebody's identified or knows somebody in that situation, they can reach out to community organizations and law firms and get further assistance.
Now, with respect to the standard, the beneficial to stay in the United States, because there's a state court that would need to be involved, I'm assuming that the standard as far as the factors that play in will differ from state to state. You did mention California. Perhaps you could maybe talk a little bit about why one individual might be adjudicated beneficial to stay in the United States and perhaps why another would not?
Yeah, so what we're looking at and the factors that we think are important are, what are the conditions in that individual's home country? So who can take care of them? Where are their care providers? Are they in the United States or are they outside the United States? What are the general conditions for the country in which they're living? A lot of the clients that we're helping in this situation happen to be from the Northern Triangle, which is El Salvador, Guatemala, and Honduras, and these are very dangerous countries for these young folks to be living in. We're seeing kids who have been threatened by gangs, and otherwise harmed, So we're looking at that, and we're looking at, okay, where is the care provider? Frequently there's a care provider here. We've seen children who aren't able to go to school in their home country because of just the dangerousness of getting to school. So we look at, okay, how are they doing now in the United States? Are they able to go to school? Do they have somebody that's looking out after them? Are they safe? So those are the factors that we think are important.
Now, if there are some listeners out there who might know a child that's in a position where they're being either neglected, abused, or abandoned, is this something that you would recommend they reach out to an organization first, or would you recommend they might reach out to the police first, assuming that there needs to be some sort of adjudication with respect to the courts?
Yeah, no, I would recommend that they reach out to attorneys. And so we handle these cases, and I think most of the organizations that I listed earlier do as well. And nationally, there's Kids in Need of Defense, or KIND, which is an excellent organization and is a great place to reach out to for assistance. But yeah, so first they would want to speak with an attorney to get a full consultation and see if they might be eligible to proceed this application.
And what sort of documentation would need to be submitted in order to, prove one's status?
Yeah, so these are individuals who are without status right now, right? So they're without legal status, but in terms of that first application with the family court or the juvenile court, I'll say, it can be proved by declaration alone. We'll frequently have a declaration by the child, and then we'll have potentially a declaration from a caregiver that is not the one that's providing actual care for the child. We may have the state of California by statute has stated that a declaration alone can be sufficient to prove those facts. You may decide to submit additional facts of country condition reports of the home country to educate the judge about how it would not be in that child's best interest to return to their home country if the region where they're from is violent and unsafe. But it's not required, but it might be helpful. It might be helpful to submit evidence to show that the child is doing well in the United States, that they're attending school, that they're able to potentially obtain insurance, and that they're moving forward with their life.
I see. Now, we talked about the T visa as not being an extremely long process in compared to the U visa. How does that work for the special immigrant juvenile status?
Well, by statute, once you get the finding from the juvenile court, which may take a few months depending on the jurisdiction that you're in, but once that finding is made, you're able to make the application with immigration. That form is similar to the Vawa form. In fact, we use the same form when we submit it with immigration. It's a long form that covers a lot of things. But the statute requires that immigration respond within 6 months. But we're seeing that there's a lack of compliance with the current law. And so it's taking about a year and a half or more to get the immigration agency that's in charge of reviewing these petitions to make a decision. Once they do, then we get into that situation again of how many immigrant visas are available for that category of young folks under SIJS applications. And for most countries, again, there's a backlog. And so although you have an approved petition, you may have to wait a little while before you can make an application for a green card. The difference between the T visa and the U visa, not to overly complicate things for the listeners, is that there is no non-immigrant status for somebody that's a juvenile in this situation. They go from undocumented to a green card holder or permanent resident. There is no kind of middle step of deferred action or then T visa or U visa. It's simply once that petition is approved, when there's a visa available, then you can make the application for a green card.
No, and that was going to be my next question was, is there some sort of deferred action step that's going to be in between gaining a permanent residency or some sort of green card?
Yeah.
But it sounds like it might be a little bit more straightforward.
There isn't, and it's straightforward, but it can be difficult for individuals since there is no deferred action kind of middle ground when that child is waiting for a visa to be available to submit their green card application. They are still without status. So that means they can't get a work card, they can't have authorized employment, and that can make it very difficult for somebody. You can think about, somebody who is, a teenager or a young adult wanting to either continue studies or to enter the workforce. It can be a challenge. So it's something to be aware of. We'd also just say, so when we are providing a consultation for somebody in this situation, we're always also looking at issues related to asylum. Does the child or the young individual maybe qualify for asylum? Are they afraid of returning to their home country because they think that they could be persecuted? So we look at that as well when we're doing an assessment.
And I'd like to maybe bring up the issue of asylum and just perhaps ask a couple questions on it. How can asylum benefit or be useful for a victim of crime or a survivor, just generally speaking?
Yeah, so we're looking. So it's always part of our full assessment of an individual is why did they come to the United States and are they afraid of being returned to their home country? So generally, somebody who's making an application for asylum needs to submit that application within their first year of coming into the United States. But there are exceptions. And so you can imagine some of the individuals we've been talking about, like somebody who might have been a victim of domestic abuse. They've lived in the United States for a long time. So then they're going to have an issue of that 1 year bar. And so then what we would need to see is if there is, well, first of all, is there a good asylum claim that they should consider submitting the application? But two, are they going to be able to overcome that 1 year bar issue? And the ways to overcome it is potentially showing either exceptional circumstances, such as maybe, a common factor might be a mental health issue. Or is there changed circumstances? Have things changed recently that now give you rise that reasonable fear of returning because of a fear of persecution? But there's also exception on the 1 year potentially for children. Children is not necessarily able and informed to make an application for asylum within their first year of coming to the United States. So they may have a reasonable argument that the 1 year bar doesn't apply to them. As long as they're still minors.
And just so our audience has a full picture of asylum, can you talk about the elements that one would be required to show to make a good claim of asylum?
Sure. So the individual has to show that they have a reasonable fear of future persecution based on membership and based on a protected ground, and that persecution is either going to happen by the government or by a group or individual that the government is either unable or unwilling to protect against. And so with the protected grounds, the traditional grounds that most people maybe know of or would recognize when they hear them are things like persecution based on your religion, persecution based on your race, persecution based on your political opinion. But there's also another protected ground, which is protected based on your membership in a particular social group. And that is an area of increasing litigation. And as we try to grapple with what does that mean, some of the earliest cases in interpreting it have said, for example, membership in a family would constitute a social group. So if you're persecuted based on your membership in a family, maybe it's based on your sexual orientation, can be social group. Can gender be social group? The definition is certainly under litigation and is certainly some are, there's some dispute exactly about what it means. But that gives you a little bit of an overview of some of the basic things that we think about family, sexual orientation.
And asylum can be made, a claim for asylum, rather, can be made even up until the 1 year mark of an individual living here unless they qualify for one of the exceptions, correct?
Right. So ideally the individual makes the application within the first year of entering the United States, and if they don't, then they would need to show some exception, as you mentioned, the exceptional circumstances or changed circumstances. And if they're unable to do that, then they're looking at related relief, which is not as more difficult and provides less rights. Asylum, eventually you're allowed to obtain permanent resident status, that green card, and then a pathway to U.S. citizenship. If you would be persecuted based on a protected ground, but you made the application late and there's no exception that qualifies, the individual will get what's called withholding of removal. So the United States is part of treaties that state that we won't send somebody back to a country where they're going to be persecuted. And so you would get withholding of removal. And I think this is going a little deep in here, the waters, but the individual will be protected. They would have the ability to get protection from removal. They're not going to be deported while that fear continues. And they might get a work permit, but they're not going to get the ability to apply for permanent resident status.
I see. And if any of our listeners have any questions either about the special immigrant juvenile status or asylum, could you provide one more time maybe some of the list of organizations that they might want to reach out to?
Yeah, certainly. So in the Sacramento Central Valley area, I'd be reaching out to our immigration clinic at McGeorge Law School, 916-340-6080. But there's other excellent organizations in our area, including Opening Doors, including CRLAF, which is the California Rural Legal Assistance Foundation, and then outside of our area in the Bay Area, an excellent organization is Centro Legal in Oakland. And as I mentioned before, they are a sort of an umbrella organization that would be a great place to start for somebody who's outside our area looking for resources.
And once again, we will provide the links and the phone numbers for all of the resources that Blake mentioned in our podcast description. Blake, thank you so much for coming on the podcast here today and discussing all these very interesting topics.
It was a pleasure to be here. Thank you so much, Nima.
Thanks so much. Now that you've heard the show, please take a moment to rate and review it. And if you have any questions about any of the information you heard today, you can reach the Victims of Crime Resource Center at 1-800-842-8467. Or you can reach us online at 1-800-VICTIMS.org or Facebook at Victims of Crime Resource Center or Twitter at 1-800-VICTIMS. If you haven't had a chance, please take a look at some of the other episodes in our series. Thanks for listening.